Take home quickie. If we're going to talk about bad income tax cases, we need to talk about 1916's Brushaber v. Union Pacific Railroad. Yes, it's yet another unanimous decision delivered by Justice Edward D. White, and this one is the one cited most often for the support of the income tax. Frank Brushaber was a French immigrant who owned stock in Union Pacific Railroad, which was chartered in Utah before it became a state. Brushaber filed suit to prevent the company from voluntarily filing income taxes, saying it would violate their fiduciary duty by reducing dividends. Once again, we have a confusing, rambling decision, which a lot of statists like because it lets them pull out whatever suits their needs at the time. The court ruled, "There can be no dispute that there was power by virtue of the amendment during that period to levy the tax without apportionment, and so far as the limitations of the Constitution in other respects are concerned, the contention is not open." So apparently a new amendment just means you get to ignore all the others, and you don't even get to argue it. And once again he worms his way around the direct tax clause. The purpose was not to change the existing interpretation except to the extent necessary to accomplish the result intended, that is, the prevention of the resort to the sources from which a taxed income was derived in order to cause a direct tax on the income to be a direct tax on the source itself, and thereby to take an income tax out of the class of excises, duties, and imposts and place it in the class of direct taxes. I know that's a sentence fragment, and I don't normally do that, but I had to because that sentence is almost 200 words long. I told you it was rambling. Anyway, the government continues to rely on this decision to support the personal income tax, even though the court said it was an excise tax, and in this case was about a federal corporation. And also they said it was voluntary. Brushaber argued that taking that money from stockholders or anyone else would be a taking under the Fifth Amendment, but the court ruled, "So far as the due process clause of the Fifth Amendment is relied upon, it suffices to say that there is no basis for such reliance, since it is equally well settled that such clause is not a limitation upon the taxing power conferred upon Congress by the Constitution." Since when? Isn't that the very reason for the Constitution prohibiting direct taxes in the first place? Check this part out. So far as these numerous and minute, not to say in many respects hypercritical, contentions are based upon an assumed violation of the Uniformity Clause, their want of legal merit is at once apparent, since it is settled that clause exacts only a geographical uniformity, and there is not a semblance of ground in any of the propositions for assuming that a violation of such uniformity is complained of. I swear, White's thinking skills were as bad as his writing skills. By the way, White sided with a majority in Plessy v. Ferguson and the breakup of Standard Oil, and decided cases in favor of minimum wage and emergency powers. Worst Chief Justice ever.